so that's basically the difference between getting a target letter or a subject letter. If you're charged, you're going to be arrested. Hello again. I'm Lana Manitta with Rawson Law Firm, and I'm here to talk to you today about federal criminal procedure. Remember to like and comment on this video and subscribe to our channel to see educational videos covering all sorts of criminal defense-related topics. So the question we are answering today is, what is going to happen to me when I get charged with a federal crime? And today we are really only talking about the procedures, the court procedures, what's going to happen in court. Because, of course, the results of your individual case are impossible to predict or even address without a case-specific review and consultation with an experienced federal defense attorney. So what we are talking about today, again, is simply the procedure that's going to be followed. Now, some of what will happen after you are charged depends a little bit on what you are charged with. But speaking in general terms, we're talking about felonies because there are really very few federal misdemeanors. So I'm going to cover what happens in a federal felony case. If you are actually charged with a federal offense, as opposed to being notified that you are a target or a subject of an investigation, then you will be arrested. Okay, so that's basically the difference between getting a target letter or a subject letter. If you're charged, you're going to be arrested. If you know in advance, because you've gotten a target letter, your counsel has been talking to the prosecutor, and they tell you you're going to be charged, we're going to indict, or we're going to file, a complaint, then the arrest can be sort of arranged ahead of time and you can self-surrender. But if this is like many cases where they don't want you to know beforehand that you're going to be arrested, you will first know that you're being charged when you are arrested. When you are arrested, whether you knew about it ahead of time or not, you will then have an initial appearance before the court. And that will be before a magistrate judge. And at that point, you're going to be told what you're charged with and the potential penalties. And you're going to be asked if you intend to have private counsel or will need court-appointed counsel. If you indicate that you're not able to hire counsel, you don't have the means, and you're going to need court-appointed counsel, the magistrate judge will usually have you fill out what's called a CJA 23 or a financial affidavit. And if you qualify, you're going to receive either a federal public defender or a private attorney who takes appointments under the Criminal Justice Act. If, however, you wish to have private counsel, you would let the court know that either you have counsel that you've already been speaking to if it's a situation where you knew you were going to be arrested, or you want to hire a private attorney for the case. If you let the judge know that, you're probably going to be asked some additional questions, perhaps about who the attorney is that you're thinking of hiring or have been speaking to, whether they've already agreed to represent you, whether they've actually been retained or hired. This is not to bind you or to trick you, but it's usually just to get an idea of whether the court actually can start scheduling things and you will have counsel available at the next hearing, because hearings are scheduled pretty quickly. Now, this initial appearance is also when the government can ask for a detention hearing if they are seeking to detain you, which means to keep you in jail while your case is pending. It's really a hearing at which you should have an attorney present to challenge this request, because under the Bail Reform Act, the government can't just ask to detain you in every single case. There are prerequisites. And so if you don't have an attorney, and it's unfortunate, but many people don't have an attorney at this initial appearance. The government might ask for and be given an opportunity to have a detention hearing and have you held in jail for another 3 to 5 days when actually they really weren't entitled to that hearing. So more and more now, the districts are having a duty attorney, maybe from the federal defender's office or a CJA panel attorney, who's present to handle these initial appearances for folks even who are going to hire a private attorney, but who don't have their private attorney present on that day because they didn't know that they were going to be arrested. So if there is somebody there to help on that day, it's best to take their help because ideally you would have representation anytime you're facing the court, including just this really simple, and that should be in quotes, initial appearance, because the Bail Reform Act does kick into gear and the government can take advantage of it if you don't have representation. So if they make a request for a detention hearing, if the government makes a request for a detention hearing at that initial appearance, and that request is supported by law, the Bail Reform Act supports them getting a detention hearing, that hearing is going to be scheduled to take place within usually 3 days of the initial appearance, unless the defendant wants more time, and then it's usually a max of 5 days later. At that detention hearing, the court must determine whether there are conditions of pretrial release that can be set, if necessary, to reasonably assure the defendant's appearance in court and, protect the community from any danger. Oftentimes, the main concern is reasonable assurance of appearance, or to put it in terms of the government's perspective, the risk of flight, the defendant being a risk of flight, just not showing up for court. Now, in most cases, the law presumes in the defendant's favor. The Bail Reform Act really says that the court shall release the defendant if there are conditions that can be put in place to reasonably assure appearance and, protect the community from any danger. But in certain cases, there is a presumption the other way. In certain cases, depending on the offense that's charged, the maximum available sentence, whether there's some prior offenses or convictions in the criminal history. I won't go into the complexities of the Bail Reform Act here, but it is the subject of another video. But, suffice to say, there are cases in which the burden of proof is going to shift to the defendant to prove that there are conditions, instead of the government having to prove that there are not conditions that will assure presence in court and protect the community from any danger. So, aside from the detention hearing, which is one of the earliest hearings in the case, if a defendant has been charged by criminal complaint instead of an indictment, there is also an entitlement to a preliminary hearing, which is a probable cause hearing. And at that hearing, the government has to prove probable cause to proceed with the case. It is a very, very, very low standard. And the government only has to show probable cause, which is, does it look like the offense was committed? Does it look like the defendant was involved? It's a very, very low standard, and very easy for them to prove. It is not beyond a reasonable doubt. It's a preponderance of the evidence. Hearsay is admissible. I mean, it's almost a foregone conclusion that they're going to prove probable cause at this preliminary hearing. In some districts, there's almost an expectation that your attorney is going to waive this hearing. That does not mean your attorney should waive this hearing. Now, you're not going to beat the case at this hearing, but it is an opportunity for counsel to get some information, to question at least one agent who's associated with the case on some of the information, and get what's called early discovery. Now, the magistrate judge conducting the preliminary hearing will probably cut your attorney off if they go too far into discovery. But if it is arguable that asking these questions and eliciting these answers on cross-examination of this agent goes to probable cause, then your attorney is going to have a little bit of leeway, and it can really often be a helpful first bite at figuring out where there might be some holes in the government's case or weaknesses in the government's case. Now, at this hearing, the government is going to put into evidence an affidavit that purports to lay out, enough information to make probable cause. And they're going to have one agent swear to the affidavit. And because hearsay is admissible, the affidavit is going to contain information from the whole investigation. And that agent up on the stand is not going to have personal knowledge of some or all of the information that's in there. They will have received it through hearsay. So again, you can imagine it's virtually impossible for the government to lose at a preliminary hearing. And the bad news on top of the bad news is that even if they do lose, the government can still take the case to a grand jury and try to get an indictment anyhow. So after those early hearings, preliminary and detention hearings, which in some districts are scheduled to take place together, but other districts they are not, one of two things is going to happen. If you haven't yet been indicted and you've had that preliminary hearing, the government is going to produce a limited amount of discovery and often will propose a pre-indictment plea. What they will often say is the best offer that you're going to get because we won't have to go to the grand jury and we won't have to indict your client. And so here's a little bit of discovery for you to figure out whether we have a good case and consider this pre-indictment plea offer that we're making. If you have already been indicted, then an arraignment is going to be scheduled, and the government is going to propose an order that will govern the way discovery is conducted in the case. They may propose a protective order to keep discovery protected from disclosure. And they may seek to have your case declared complex, which will toll certain deadlines, including speedy trial. And they may also still produce some limited discovery and make an early approach to see, whether you are going to be amenable to a plea offer or not. The government might also propose what's called a reverse proffer, where they will sit you and your attorney down, present a summary of their case so that you can make a decision and decide whether to start thinking about plea or a trial. So then once the indictment comes down, you have an arraignment. An arraignment is a very short hearing. You formally enter your first plea, which is always not guilty, and dates are scheduled by the court, either for motions and trial or for a status hearing if the case is going to be complex and, the parties are not ready to set it for trial yet. After the arraignment, there are usually no court dates immediately thereafter. The next court dates are going to be either a plea hearing or a motions hearing, or a status hearing. And those are, all of the options for the next hearing. Once the parties have determined that they are, going to trial or having a plea, we will either have a plea hearing or we will have a trial. If there's a trial, there are pretrial motions that are set. There are maybe conferences with the court to deal with jury instructions or voir dire, and then there is trial. Now, in some districts, this process that I have just described to you can take years. In others, the goal is to wrap this up in 6 to 9 months. And it's very important when you hire an attorney that you hire someone who is familiar with the district in which you are charged, because not all federal districts operate the same way. And you can find yourself hiring a superstar attorney in one district who winds up rubbing the judge the wrong way in another district on day one because they just haven't taken the time to familiarize themselves with the standards and the protocols of the particular district that you're charged in. And so this doesn't mean that you have to hire an attorney who always practices in your district that you're charged in, but you have to hire someone who can articulate to you how they are going to familiarize themselves with the norms of that district. And if they're not prepared to do that, or they don't have a plan to do that, or they don't have a regular way in which they do that, I would be very concerned. It's really an easy thing to do to consult with local attorneys, especially the local federal defender or the CJA panel representative, attorneys who appear regularly in that court, to find out the idiosyncrasies of a particular district, a particular division within a large district, or even a specific judge. But you would be very surprised how many attorneys don't bother to do this. And I don't know if it's an ego or a laziness thing, but they show up and they make fools of themselves because they don't know how things are done in that particular district. And if you're there as the defendant and your attorney doesn't know what they're doing when they get there on that first appearance or that detention hearing or a preliminary hearing, that is really not going to lay the groundwork for you to have a great deal of confidence in your counsel. It's certainly not going to strike fear in the hearts of the prosecution, and it's going to annoy the judge. Now, in many cases, if your attorney does not regularly practice in a particular district, they're going to be required to hire local counsel to sponsor an application to appear what's called pro hoc vice in the district. Some districts are very strict and will require that local counsel to be present at every hearing, to review every pleading, sign every pleading, and basically serve as co-counsel who is ready to try the case by themselves if necessary. Other districts require nothing but local counsel signing the sponsorship form. But in either case, local counsel should be somebody who knows what they're doing in that district and can be the necessary resource for you and your attorney to know what's necessary in that district. So that's all for today on what will happen if you are charged federally. There's a whole lot more that we can talk about, but let us know what other topics you'd like to hear about. Like and comment on this video, subscribe to our channel, and as always, thank you for watching.